The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Morning, Judge Keenan.
Good morning.
All right, good morning. Welcome to the United States Court of Appeals for the Fourth Circuit. We have two cases on for argument this morning. First up, 25-1728, CLG versus South Carolina Department of Social Services. Mr., is it Butcher or Butcher? I'm sorry.
Butcher, like the meat cutter, Your Honor?
Yes, sir. Okay, well, you're up.
Thank you. Good morning, or I'm sorry. May it please the court? My name is Robert Butcher. I have the honor of representing CLG and CNG. These are two minor children whose foster parents were gracious enough to provide foster care services in the state of South Carolina. And this case is about the affirmative placement decision that DSS knowingly made, that Carrie Register was the DSS employee, and it created a foreseeable risk to two identifiable children. When this case was referred to me, I immediately thought this state created danger. You know, we certainly know that the Doe case, Doe XRL Johnson versus DSS, which was issued by this court in 2010, protects children in the custody of the state of South Carolina. That is the differentiation. So it is definitely not on all fours. But what we believe that does is it provides the framework for for protecting children and not endangering children from a legal aspect. We know that there are professional social work standards where you don't place sexually aggressive children with younger and more vulnerable children. But the court said, hey, this is not good. And we also have plenty of criminal statutes and that type of stuff. So bottom line was, did Carrie Register know at the time that placing a child with a propensity to sexually act out on children, not just they might, but a documented history that she knew
Mr.
about.
Butcher, can I ask
Yes.
you a question about Ms. Register and exactly what you alleged in the complaint?
Yes, Your Honor.
Maybe I missed it, but it seemed like the complaint doesn't really directly allege that it was Ms. Register who was responsible for omitting the information that you think should have been provided to the foster parents. Is that the allegation? I mean, even the complaint doesn't seem to say that, though.
And the complaint wasn't very certain at the time. So,
What's the answer? Yes or no?
Yes,
Okay.
the complaint does not say that, but we've learned through the process of discovery that Ms. Register actually had her hands in the placement decision and the that she made the placement decision. So what South Carolina has done in certain regions is they have a placement hub where they basically call up on the phone and get a foster placement from 4 or 5 or actually probably less employees of DSS. But here, Register was called and said, I have a kid that needs placement, and didn't bother to say, oh yeah, by the way, this child likes to have sex with other children, and you have 2 young boys, or actually 3 young children in the home.
Okay. So you made reference to the Doe case, and
Yes, sir.
I think we all are familiar with that case, but how would that case have put Ms. Register on notice that she had an obligation to inform the foster parents of the negative tendencies of these children? What Doe stands for is what you just said, that the social workers have an affirmative obligation with respect to children in their custody. But these children who were allegedly harmed by the child who was placed in their home, they were not in the custody of the Department of Social Services. How does Doe put Ms. Register on notice of her obligations?
Yes, Your Honor. So, and I apologize. So, what we are arguing is that under the state created danger theory, that bottom line, that there was an affirmative act, and a known risk, and,
So you agree it's not, she wasn't put on notice by Doe, you think she's put on notice by the broader state-created danger doctrine?
I think that's where the court should ultimately end up. But
Because you sort of began by saying Doe itself is not really the case we've got. It's got some broad principles that apply, but it's not the case. We really need to look at the state-created danger doctrine to put the defendant on notice here.
Yes. Judge Diaz, he framed the holding of Doe, but it also, from a broader standpoint, for the caseworkers, it basically says, don't endanger other children with your placement decisions,
Okay, but Mr. Butcher?
Yes, Your Honor.
Mr. Butcher, how do you meet the clearly established prong? Where is the clearly established principle that the state's duty extends beyond the child in the state's custody to foster children who are in a house or home that receives the placement child? How do you get beyond that? It seems to me that that's your real hurdle.
It is my real burden, and so what I was saying under the Doe ex rel. Johnson, from my perspective, my view is that this court already recognized that there's a known risk of sexual abuse in placements when you place a sexually reactive child with other children. And then we also believe that Hope, Taylor versus Riojas, those cases show, and they're certainly corrections cases, but what you have is the affirmative act where a state has custody and control of someone. And
What about if I had children that were in the school district?
right,
And the foster system put a allegedly sexually dangerous child in a foster home, and that meant that child went to my children's school.
yes.
Do you think that the foster agency would be responsible to the parents of the students, or to the students that are in that school because they, failed to notify the school officials that, a sexually dangerous child was now going to be attending the school?
No, I
So
don't.
why not? Because it sort of seems like that's the same, if it's clearly established that it extends beyond those in, DSS's custody, why do we draw a line at those that live in a home versus those that go to a school?
I think because the victims are clearly identifiable in this matter, where a school, it's much more
The
general.
question of whether they abused them or not, I mean, they're going to be identifiable because they were children who were abused.
No,
So they're identifiable. We know their names.
the victims,
Yeah.
I mean, afterwards, but here,
Yeah, but that's the question, right? Is that you only know that they're victims once they've been abused. And so it seems like to me that your approach would suggest to us that DSS, in my example, negligently, placed a child in a position to go to a school, and didn't notify the school or the parents at that school that they were doing so.
Right.
And that would have the same sort of constitutional implications as you have here. I
think it's broader on who
Right, but
state-
why do you think that it should be different, right? Because obviously, if that's true, we go down a long road, right?
Right.
Because we've got schools and we got gyms and we've got, music classes and, we've now opened up sort of liability on constitutional grounds to a pretty broad set of folks. But,
Yes.
and so I guess I'm having a hard time seeing why these children who were not in DSS custody are different from other children who are not in DSS custody, who are exposed to, a foster child through the negligence alleged of DSS.
I think also because in the social work problem, that, using your rules, your professional social work standards, when you're matching up a foster child with a family, the caseworker is required to actually look at who's in the household from every adult to every child and make sure that it's appropriate.
And so we think that the constitutional rule turns on the DSS rules? So DSS happens to define that as the rule and that's where the constitutional line comes from?
No, Your Honor, I think what I believe I've identified as, the essential elements in state-created danger is that there is an affirmative act, there's a known danger, and there are identifiable victims, where, there creates this actual responsibility, a responsibility to the people that get harmed that are known beforehand. They don't know who's in the school or what's in the school, and they don't investigate the backgrounds of those people. The state has taken more action, they essentially have more responsibility to know, who all is being, who could be harmed in that situation.
Can I
Schools,
go back
we don't know,
to
yes.
Judge Keenan's question about, we've got the principle of state-created danger, that's fairly well established, but the Supreme Court has told us time and again that when we're dealing with qualified immunity, and in particular the clearly established prong of that qualified immunity, did we lose?
I think we just lost,
No.
maybe.
Are you still with us, Judge Keenan?
Yes,
Okay,
Your screen here is something different
the
now.
monitor in front. Can you just stop the clock for? yeah.
What's, the screen on the bottom?
Oh, look, I don't, yeah. Let me contact IT.
Okay.
I think he's on it. Can you, let's see.
Yeah, so long as Judge Keenan can still hear and see us, then we're
She
good.
is on, is that?
yes,
Okay, great. We can start. So anyway, sorry, Mr. Butcher, back to my point about qualified immunity. The Supreme Court has told us time and again that we can't define the principle at too high a level of generality, right? And so we have to, if we're going to hold people accountable under Section 1983, they've got to have fair notice that what they were doing violated clear principles so that only the most plainly incompetent public officials are on the hook for their misconduct.
Okay.
But you're making a pretty good argument, I suppose, that we might want to extend the clearly, the state-created danger to these set of facts. But that doesn't help you with respect to the second prong of the qualified immunity analysis, because it seems to me that Ms. Register would not have been on notice that she had to abide by this principle.
Well, I think that there are certain, when you have clearly established, of course, that's the easiest part.
Easiest for who?
Well, for the plaintiff, when you have a case on all fours, the Doe case, that's, something that we litigate often, but here, so, from our perspective, the let me rephrase this. So, the school example, and that's what I really was thinking this morning is that it's more than just a student body population. It is two known children who they knew the age and their abilities. And she knowingly and intentionally placed this child, knowing that this child would sexually act out on these two children. So when that occurs, then, you know, Malley versus Briggs does say it protects all but the plainly incompetent and those who knowingly break the law. And here, she, you know, foster care, South Carolina's chronically short homes. And one of the things during that time is, you know, that she wanted to find a place for that child so she didn't have to sleep in a DSS office or at a hotel to keep the child. So from our perspective, she intentionally harmed these children by placing a snake in the crib of these children.
All right, Mr. Butcher, I'm going to stop you because you're over time. You've got some time left for rebuttal, but before you sit down, I want to be sure that Judge Keenan doesn't have any additional questions for you.
Thank you, Chief. No.
Okay. Do you? All right, thank you very much.
Thank you.
Mr. Montgomery?
May it please the court, it's a pleasure to be here with you. I thank you for hearing our case today, and I don't know, walking over today reminded me the first time I came to this court, which is longer ago than I want to admit. But the real question we have here today is a pretty simple one. And it's a simple question is, did the district judge correctly rule that Ms. Register is immune from suit under the doctrine of qualified immunity? And we believe the simple answer to that is an emphatic yes. While the appellate here has painted, you know, a picture with facts and allegations, and obviously we understand that we're looking at summary judgment, everything gets to be skewed as far as the court determines those facts are in the light most favorable to the non-moving party. So accepting that, we're still faced with the fact that the plaintiff in this case is unable to establish a right, a constitutional right that has been protected, that is a known right, and that is one, as we put out, that she clearly knew she was violating with her placement. And I'm going to refer to the child, JF, as Zoe because it's easier not to use initials. But I want to note something that I think is really critical here.
Can I ask you, Mr. Montgomery, you
Yes,
just
Your Honor.
conceded that we have to accept the facts as alleged by the plaintiff. And when I read these set of facts, and of course, they may be disputed, you know, there may be some nuance here, but if we accept the allegations, it seems obvious to me that a social worker shouldn't place a child who might have tendencies to abuse other children in a foster home without telling the foster parents that that might be a possibility. It just seems like so obvious to me.
Well, I think obviously the first question is, you know, these are allegations. There's no real
I understand
evidence
that,
in
but
the
you just told me that the allegations are to be accepted as true.
I understand that.
So let's start with that premise. Then why isn't that so obvious that the social worker shouldn't do that?
Well, I think the question of fact is, what did the social worker know and not know? And the allegations that have been made.
Right, but you're actually not disagreeing with the chief, right? If these facts are true, right?
Yes.
Then everybody would acknowledge that the DSS should not have done so. That is not the same thing as admitting that there's a federal constitutional claim.
Correct.
Right? There might be all kinds of negligence claims. There might be indeed criminal liability under state law. There might be a variety of different, you know, disciplinary actions that DSS could take. You're not actually arguing that if these facts are true, that DSS did a good thing here. Your argument is limited to saying it's simply not a federal constitutional issue.
That is correct.
Right.
Judge
Okay.
Rich. My argument, and I point out that the chief judge.
Because we will acknowledge that whatever happened here should not have happened if these facts are true.
I agree with you.
Right,
And
okay.
I point out that, you know, Chief Judge Diaz had a case last year, the Gellin versus Baltimore County case, which I would suggest the facts were even more horrific than they are here. The the judges, the correctional officers listened to the inmates screaming about a young lady who was about to commit suicide. She did. There were no rounds made, and yet there was still a finding that there was, in fact, qualified immunity because there was no known right in the way that the case was pled was very similar here. There's no defined right that's pled or mentioned as to what constitutional right these children have. And we'd all agree that, and I would take your questions, Judge Richardson, and expand them even further. The child gets a job. One of the things that came out in the discovery here is that the foster parents were wanting Zoe to get a job. She gets a job and goes and does something. You know, I mean, at what point does that constitutional burden that the plaintiffs want to imply, it extends to the world? And I think that one of the important things in looking at the statutes that they cite, which again, I think we all agree that no court has said that a state statute serves a basis for a federal constitutional claim in this circumstance. But the statutes that they cite show the wisdom of the General Assembly in protecting the children in the state's custody. They don't expand that and say, oh, we're protecting everyone, because you open Pandora's box. And the other thing that I want to emphasize, which I think has not been emphasized, is this is not a mandatory placement of a foster child. These parents, as the record reflects, not only have the opportunity to ask any questions they want, but this particular set of parents says, oh, in fact, DSS misrepresented other children to us, and they want to use that as a basis for imputing bad conduct to DSS, but I would suggest to the court that it also suggests that they weren't paying real great deal of attention. And you know, the other thing that is admitted in the facts, and there's no dispute about, is that these parents acknowledged that this child was not to have access to a cell phone, he was not to have access to the internet. Yet, the very complaint that the plaintiff makes inures only because that occurred. And, you know, there is no allegation, there's no evidence in the record that this child, Zoe, ever touched the two children in the home. The only evidence in the record is that this child showed them pornographic video, and in fact, the father's testimony is that the search history for the pornographic sites went all the way back to November, which was before this child was in the house January 5th, and that he exposed himself to them, and there's some allegation that either he did or did not masturbate. But there's no touching. There's, you know, it's not something you want your children to see, but there's a real question of how there's harm, and I point out there's no expert report to suggest that there's any deficiency in anything, although.
But is any of that, I mean, you just gave us 5 things that none of them seem relevant to what we have here, right? I mean, maybe that goes to a question of damages or injury, but nobody's raised that to my knowledge here. Maybe you have a contributory negligence claim if we lived in a world where contributory negligence was relevant to our federal claim here, but I don't think we are, and so maybe that's going to be a good argument when you end up back in state court. I guess I'm not sure why. I mean, I understand your primary argument. The last several things that you've just said where you're impugning the parents, I guess I don't understand why that's relevant to what we have to decide.
And I'd first suggest, court, I'm not trying to impugn the parents. I'm just trying to reflect that when we look at this, we have to look at this in totality, and where is that constitutional right? I mean, there has been no indication, there's been no case cited. The closest they cite to a case is Doe. There's no recognized authority cited. They go into a danger kind of issue. But one of the points I was trying to make to the court there is that there is no direct affirmative act by the state to create a danger. The danger was created by a number of events, a sequence of events, if you will. And the so-called comparative or contributory negligence is simply an indication that if you're looking at a state-created danger, the proximate causation of that state-created danger was not the action of the state. The state didn't take an action as it related to the two children who are plaintiffs here. The state entered into a contract with their parents where their parents agreed to serve as a foster child foster parents for this child. And so we're not talking about a situation, and I know we often deal with qualified immunity in a corrections sense, but we're not talking about a situation where the state had custody, the state had control, the state had action. The state, if you look at the facts as they're presented, makes a phone call, someone says yes, that someone says, well, what information do we need to know, or something to that effect, and the state says, this child is not to have internet access, this child is not to have access to a phone, this child has been sex trafficked. Those are undisputed facts in the record. And they want to suggest that, oh, we had notice of other things and they should have told us, but I'd suggest that when you're talking about from a constitutional standpoint, what's been provided certainly puts them on notice that there's an issue with this child and that it's sexual in nature.
Would the result be any different if the children who were allegedly abused were also foster children who were under the custody of the state?
Your Honor, I think that's clear. I think that's the Doe case, Doe versus South Carolina DSS per se. That would be different. And that's where we get into that whole expansion circumstance. If we start expanding the universe of constitutional protection beyond the people that are in the care, custody, and control of the state, then that opens the door to everyone. The child goes out and, again, school, work, music lessons, all the things that Judge Richardson cited. Where do you draw the line? And Mr. Butcher says, well, you know, they know about these people. Well, I would suggest that the real problem would be the people they don't know about. The parents whose children are in that school that don't know anything about this child, don't know their foster child. You know, they could invite them into their home. I mean, there are all kind of permutations, which is why the law is so clear that you have to have a clear and absolute kind of finding. And it doesn't have to be on all fours, clearly, but there has to be a reasonable way that Carrie Register, as a defendant here, would have noticed that, oh, if I do this and place this child, I'm violating these other children's constitutional rights. And the plaintiff appellant has not presented any evidence to the record that reaches that threshold. And I think sometimes you can look at, if you will, the idea of the cases that we deal with that are where constitutional qualified immunity is denied as much as the ones that where it is adopted. And you know, I note that in this case, the other thing is that this child was in their home for about 6 weeks. Beg the court's indulgence just a moment. Just when we look at the record in this case, as to far as what is unnecessary and what is harm, I look at some of the court's recent decisions that I point out. This month, in the case of Bolick versus Anderson, which you just released the 13th, last week, you found qualified immunity in you denied qualified immunity, but you denoted in that case that a prisoner had been kept without access to exercise for 324 days, and that there were clear case law that showed that that was a requirement. In Barkles versus Wright, which was decided 3/3 of 2026, the court said that there were 5 specific cases on point that found that constitutional right. And in Cox versus Quinn, there was a exacerbation case, and you know, there was a case, it was clearly established when the right was. And so I think the big issue that we're looking at here is, what can the appellant show this court that clearly establishes a right? They want you to extend a right, okay, but I would suggest to you that the extending that right today does not put Carrie Register on notice of that right January 5th of 2022. And so that's the environment that we have to look at. What did she know or could she know on January 5th, 2022, that would have let her know that if I do what they say she did, that I have violated these children's constitutional rights? Under the 8th, the 14th, whatever amendment you want to look at. They say the 14th, but they've really never indicated exactly what right they were violated other than to be safe. which is what they say in both their brief and their pleadings. So what did she know that day? Yes, you're right. Maybe there's a negligence case here. Maybe there are lots of other questions here. And of course, the district court took those state law claims and said, I'm not accepting jurisdiction on those. They go back to the state court. So denial of this does not deny the plaintiff her day in court. It just puts it at a different place and under a different cause of action with different standards and rules. I can only say that we all see cases that have horrible facts and horrible situations, and the old adage that bad facts make bad law is certainly true. And I would certainly encourage the court to look beyond the claims and the facts, and again, recognizing that what's recognized as fact in this case may or may not be the real facts in this case, and look at it from a standpoint of, was that clear right there? Was that clear right available? And on January 5th, 2022, is it reasonable and is it proper and is it appropriate to say, there is a clear right here, Ms. Register, you should know about it, and you know that if you do this, and then what did you do, allegedly? You didn't tell them all of the history of this child, because you told them some. You told them enough to prevent what happened had they followed your recommendation, but they didn't. And that's the parents, not the children. And so we would suggest, and I'm not going to take time talking because I know y'all don't want to hear me talk if you don't have any questions. So I'm going to thank the court and ask you to please affirm the lower court.
All right, thank you very much, Mr. Montgomery. Mr. Butcher?
Yes, Your Honor. So I think going back to Judge Richardson's questions, I think what does distinguish it from placement in a school is the intimate knowledge that the agency has and is supposed to have of the contents of the family. The other thing is...
But, I mean, I don't want to belabor this, but
Yes, sir.
I'm quite confident the evidence would show that DSS is aware that the third grade has students in it, right?
Yeah, yes.
I mean, so, like, the fact that they knew there were children here, they surely know that the third grade has children in it.
Yes, Your Honor.
They may not know their names, but the names don't matter, right? Doesn't matter whether they knew the names of these. They know that the third grade has children in it. And so if this Zoe is sent to the third grade, there's no doubt that there are children where Zoe is going to be.
Well, Zoe wouldn't be unless it's a SCISA school. I mean, because Zoe was 16, so Zoe
I'm
wouldn't
picking a
be-
date, fair, all right, 10th grade. They are also aware that the 10th grade
Yes.
has children in it.
Yes, Your Honor. Yes. I do understand that. I just believe that the agency has more of a special relationship with that family. And when they know the actual contents of the family, that the child spends the majority of their time in that home asleep, or, where they're supposed to sleep, I think those create more of a responsibility by the state not to place, a danger in that home, and so, I mean, I think we meet the elements that when something is so obvious that you don't, I think everybody knows you shouldn't place a sexually aggressive child with younger or more vulnerable children. I mean, that's, who do you have to tell other than people we send to prison, right? But here, that's exactly what they did. They ignored all their knowledge of this child's background. DSS had provided post-adoption services, and so they knew this child.
Just one question to make sure I
Yes, sir.
understand. So is your argument that even with full disclosure of all facts, that DSS would have violated the children's constitutional rights by placing this child in the home? That because it's a sexually aggressive child, and so placing, in some places you say, this is effectively a failure to disclose case. If they had told the parents and the parents had knowingly adopted or let that child in the house, that wouldn't violate their constitutional rights. But just now, you seem to be saying you just can't do it at all. Even with full disclosure, it would violate the constitutional rights. Which is the argument that you've presented here? I understood it to be an informational issue, but the argument you're saying is that, like, you cannot place a child like this in a foster home, period.
With younger,
children.
younger and more vulnerable children. Yes, Your Honor. Even if a parent said that, I mean, that would be, that, oh, you're welcome to have Johnny, Chester in my home, even though I have a, 5 and a 7-year-old. I mean, yeah, that would be, yeah, that would be, I mean,
That would violate the constitutional rights of the 7 and 9-year-old.
Yes, sir. Yes, sir. I believe so. I mean, they're not a party to any contract with DSS. And DSS has to make that assessment on safety, just like,
Rather than the parents, right? So the parents' responsibility to their own children doesn't matter because DSS has a responsibility to children that are not in their care and custody, who happen to interact with children that they place.
Yes, Your Honor. I believe they have special knowledge and understanding. I mean, there are a lot of people that don't understand that, when children have sex with other children, it's kind of like spreads like a virus through a household or through a group home, because the children get so warped that they don't understand, that they seek the sexual feelings, but they don't understand what they're doing. It really warps their understanding of love, intimacy, because they're not ready for it. But I mean, that's more the
Can I
psychological.
take you back to just
Yes.
so I understand the right at issue here? In your brief, you first began with a claim that the right at issue was, that the genesis of that right was state statutes, a state statute that purported to protect foster children in the custody of the state. Are you walking that back? You're no longer relying on that?
No, I think that more points towards the obviousness that what they were doing was wrong,
But do you agree that the genesis of a federal constitutional right can't be a state statute?
Right, I do understand that.
Okay.
I do think, though, that, when we're looking for what is obviously, things that put people on notice of what is so obvious. I don't think you have to read case law to determine, to figure out that, you shouldn't place children with, sexually aggressive children with other children. And even in a foster home. And the foster home, the children of the foster parents are the least able to protect themselves in this whole situation. If no one is looking out and doing the actual social work problem of determining, the safety of the placement. And they used to call it matching, but, bottom line, when they do look at a home, from a matching perspective, they need to make sure that there's no one that can harm them or harm themselves, or that they can harm. Same with violent children. You don't put them with someone who can't defend themselves. My time's running out. Is there anything else?
Judge Keenan?
No, thank you.
All right, thank you very much, Mr. Butcher.
I appreciate it. Thank you.
I want to thank both counsel for their arguments this morning. We'll come down and greet you and then move on to our second case. Did? Our second and final case for today, 25-1258, Piatra versus Attorney General Bondi. Mr. Winograd, good to see you again, whenever you're ready.
Likewise, likewise, Your Honor. Thank you, and may it please the court. The Board of Immigration Appeals held in this case that a guilty plea my client entered in 2006 qualifies as a conviction, even though that plea was vacated and the charge against her was dismissed. That conclusion must be reversed under the Supreme Court's intervening decision in Hewitt, which held that Congress legislates against the presumption that criminal defendants whose convictions are vacated are deemed not to have been convicted in the first place. What matters under Hewitt is not why a conviction was vacated, but simply whether it was vacated. And my client's conviction was indisputably vacated, given that her case was restored to the trial docket and the case against her was dismissed.
Can I ask you about that? That seems like a broader argument than the one that was made below. It seemed like were you the lawyer below?
I was not, Your
Okay.
Honor.
Seemed like the counsel below sort of accepted this premise that there's a distinction between a vacatur for merits-related issues and vacatur for rehabilitative purposes. So why would we consider this broader argument?
Sure, exhaustion does not apply here for three reasons. First, the board was powerless to overrule matter of Pickering because the Attorney General adopted the same distinction in matter of Thomas and Thompson, and the board, of course, cannot overrule the Attorney General. Second, even assuming that the board could overrule matter
So
of
that's a
Pickering.
futility argument?
That's a futility argument, but even if the court doesn't accept that argument, the Supreme Court held in Santos-Zachariah, well, the statute only requires exhaustion for remedies that are available as of right. And the Supreme Court held in Santos-Zachariah that the phrase as of right refers to review that is guaranteed as distinct from discretionary or contingent on discretion. So like this court, the only way the board can overrule its precedent is to go en banc and for a majority of the full board to overrule its precedent. And just as this court is not obligated to consider a petition for rehearing en banc, the board is not required to consider a request to overrule its own precedent. So just as litigants do not have to exhaust a claim that this court must overrule its precedent before challenging that precedent before the Supreme Court, non-citizens at the board do not need to ask the board to overrule its precedent before challenging that precedent before this court.
Boy, that's a mouthful.
Well, I think that's what follows from Santos-Zachariah. Santos-Zachariah said exhaustion is limited to remedies that are available as of right. And there is no right to have the board reconsider its own precedent, just as there is no right to have this court reconsider its own precedent. And even if exhaustion would have been a problem beforehand, before Hewitt, exhaustion does not require parties to foresee arguments that are based on future Supreme Court decisions. So we think Hewitt not only requires a ruling in our favor on the merits, but overcomes any exhaustion problems that would have existed beforehand. Now,
All right, I'm sure you have a plan B if that doesn't work, so.
Between Santos-Zachariah is very clear that exhaustion is only available for remedies that are available as of right. There is no right before the board for the board to go en banc, just as there is no, there's no right to have this court go en banc. I just find the two analogous. Now, and of course, this court, cannot disregard what the Supreme Court said in Hewitt, which, as I said, was that Congress legislates against the presumption that vacated convictions are void ab initio. Now,
So
yeah.
Maybe, and I'm not suggesting this is where I am, but let's say I disagree with you on that broader principle. We can still rule in your client's favor if we simply look at the nature of the vacatur in this case and say that on its face, it doesn't appear to be a vacatur based on a rehabilitative purpose, right?
Certainly, Your Honor. Even if we assume that matter of Pickering was correctly decided, the vacatur in this case does satisfy the board's own test.
And does it matter that there seems to be a mismatch between the statute that was relied on, the North Carolina statute, which seems to talk about newly discovered evidence, and the basis for the relief requested, it would seem to suggest either ineffective assistance of counsel or the lack of a voluntariness when it comes to the plea, because Mr. Pietra wasn't aware of the immigration consequences of pleading guilty.
We don't think it matters, because at bottom, the government's argument is that
Wait, why? It doesn't matter that you don't satisfy any of the statutory bases for the vacatur, except for, I mean, the only one that you plausibly satisfy, because the ineffective assistance of counsel is not retroactive, so that doesn't qualify. The only one that you qualify for is like manifest injustice. And it seems to me that the only manifest injustice that was presented was the immigration consequences, which might well be manifest injustice, but at least under Pickering doesn't seem to help you.
Well, no.
So like, help me understand why you think it doesn't matter that the statute doesn't like permit what you actually got, except for this manifest injustice piece?
The ultimate question is not whether it should have been granted under North Carolina law. What the government is effectively trying to do is collaterally attack the court's decision to.
I don't take it that at all, right? Like, one of the options available under the statute is manifest injustice, and that's not defined, but could certainly include immigration consequences. But it seems like Pickering, which is the only thing that like is plausibly available at that point, it certainly doesn't include things like non-retroactive Supreme Court cases, because that would read out a whole section of the statute. And so it seems to me most plainly that the court was entitled to do this. I'm not suggesting that you're collaterally attacking the state for doing it, but that the state did it for the purpose of removing the manifestly unjust immigration consequences, which it's entitled to do. This isn't a critique of the state. The state has every authority to do that. The question is, if we're applying this Pickering test, bracket that for a minute, but if we're applying it, it seems to me like fairly straightforward that it falls on the wrong side of that test.
Well, no,
Help me understand.
The statutory provision under which the conviction was vacated was 15A-1415C. That wasn't the manifest injustice provision. That is provision that requires new evidence having direct or material bearing on the defendant's guilt or innocence. Now, the government doesn't dispute that it can.
I take that's got to be like a Scrivener's error, because there was no new evidence that was presented. That can't possibly have been the basis on which the court acted.
If the court looks at page 85 of the joint appendix,
Okay.
the caption of the motion says, "A motion for appropriate relief pursuant to North Carolina General Statute 15A-1415C."
No, that's the motion, but the court's order does not do that, does not rely on that subsection, right? Does not identify this. I mean, maybe I'm reading it wrong, right? But I'm on 86, and I see. Am I missing something?
It doesn't cite any statute.
I understand that you claimed that it was new evidence, but anybody looking at a claim of new evidence, given the motion that you made, would be like, well, that doesn't work, but what might work is something else, right? And so I take the court's order here to sort of effectively acknowledge that the argument being made is frivolous, in my view, but that doesn't mean that it wasn't allowed to do this. It just had to do it on a basis that wasn't frivolous.
What the order says is it pursuant to the defendant's motion for appropriate relief, pursuant to the motion. And the only statute cited in the motion is subsection C, which in turn requires the presentation of new evidence.
And in your view, that if that had been the basis for the relief, no matter how frivolous, we shouldn't look behind that?
Yes, by analogy, just as a non-citizen cannot collaterally challenge a criminal conviction in removal proceedings on grounds that he was wrongly convicted, nor can the government collaterally challenge a vacatur of a conviction on grounds that it was wrongly granted. It's simply a matter of what's good for the goose.
I'll acknowledge that makes a ton of sense, but that is the argument that Pickering is flat wrong, and I'm very open to that argument. But if we say we're going to apply Pickering seems like defined by the idea that it's looking at the underlying reasoning. And when we go to the underlying reasoning, we're not undermining it, right? We're not collaterally attacking it, right? It seems like to me what the government's argument here is that this was a perfectly lawful state vacatur, right? They're not saying that it's an unlawful state vacatur. They're just saying that it's a state vacatur that is based on a reason, it has to be based on a reason that doesn't qualify under Pickering, right? That is the manifestly unjust immigration consequences. All right, like, that's not collaterally attacking. That's trying to identify what is the reason underlying the vacatur. And Pickering seems to require us to do that. Now, how you get that out of the statute, I have no idea. But like, that's what Pickering tells us to do. No? Like, what am I missing here? It's not a collateral attack on the order. It's an attempt to identify what is the reason behind the vacatur. And your argument is, well, that's crazy, right? Okay, but take that up with Pickering.
Sure.
Right? So we're not saying, it's not a collateral attack on the vacatur. It's an attempt to identify what is the basis for the vacatur, and that's what Pickering tells us to do. I mean, I acknowledge your argument is a very persuasive one, that doesn't make any darn sense. But if we're gonna apply Pickering, I don't know what we're doing but looking at what the reason is.
Sure, the last thing was, I think even under Pickering, you look at the statute under which the vacatur was granted, and you look at the order. And I don't think you look beyond that. We're not going to be
But the
subpoenaing
order doesn't
judge.
identify the statute. I understand you have this argument that we should imply that it adopted this frivolous argument, but I don't think the order requires us to do that. It seems like to me the order just says I'm vacating, right? And so we look at what is a plausible basis for that happening. And if there were multiple, maybe you get the benefit of the doubt. But it seems like to me there's only one plausible argument, and that's the manifestly unjust immigration
I think it could also be ineffective assistance, even though PDEA doesn't reply retroactively, because parties can waive arguments against retroactivity. And here the government, the North Carolina prosecutor, did not object to the motion. Sorry, I see that
Judge Keenan's
had a
hand was up.
question.
I'm
Yes.
sorry, Judge.
Yeah, no, I'm sorry, I wanted to get the right time to ask, I didn't mean to cut across anybody, so if you're still answering the
No,
question, please.
by all means.
Okay, it seems to me, Mr. Winograd, that the only basis that you could possibly fit into the Pickering framework would be the voluntariness of the plea, because that would be a substantive or procedural, however you want to define it, defect in the conviction, okay?
Yes.
But in order for us to find that, wouldn't we be looking behind the state order to try to figure out why it happened? In other words, nothing in the motion of the petitioner suggests that the plea was involuntary, at least under the laws that then existed. And nothing in the court's order indicates that the plea was not voluntary. So, you've got a very sympathetic case, but how do you get there without asking us to try to figure out why the court did this?
Well, the board has recognized, and certainly the Ninth Circuit recognized in Bent, that whether a non-citizen understands the immigration consequence of a plea does go to the voluntariness of the plea. And of course, the order in this case did refer to the fact that my client did not understand the consequences of the plea.
The motion did.
Had the Supreme Court recognized the problem, in other words, the failure to notify of immigration consequences at the time this motion was made?
I don't believe the Supreme Court itself has recognized that, but I believe the board and circuit courts have. With my remaining time left, if I could return just to our challenge to matter of Pickering in the event that the court finds that it doesn't need to be exhausted under Santos-Zachariah, there is nothing in the statutory definition of conviction that supports the distinction that the board drew in matter of Pickering. Regardless of why a conviction was vacated, a vacated conviction is still a vacated conviction. And this distinction may make sense from a policy standpoint. It is completely divorced from the actual text of the statute. And it's telling that the government, yes.
Do you agree that there's like a plausible, maybe not a good one, but there's a plausible argument that any vacated conviction counts, or that no vacated conviction counts? You could at least in theory get those two answers out of the statute.
Yes,
But what you can't do is get Pickering, which is like a mishmash of nothing.
Right, this is a baby that cannot be split. And I think the first option, that all vacated convictions count, even the government disclaims that, because it would mean a conviction vacated due to actual innocence would still count for immigration purposes. And it would border on the absurd to think that Congress intended that, especially in light of the presumption it recognized in Hewitt. Now, I would note, though, that another problem with the government's argument is that it just simply has not explained what its position would be if prosecutors had elected to retry my client on the charge to which she pleaded guilty. So if my client was found guilty after a retrial, would the government say that she has 2 convictions for the same offense? If she was acquitted, would it then say that
It doesn't matter whether she has 2. The question is just, was she convicted? I don't think that, can I ask a slightly
Yeah.
different question? Sorry, just to.
By all means.
So, except hypothetically for a minute that I think Hewitt is not sufficiently on point to be irreconcilable with our decision in Fan, which applies Pickering. And so assume for a minute that the only case that I'm looking at to determine whether Fan remains binding on me is Loper Bright. Can you just give me, in that context, which is slightly divorced from your briefing, how you think, in light of Chavez and Ozarumba and all the other cases that have tried to figure this question out, how this court ought to approach a case like Fan that is obviously methodologically irreconcilable with Loper Bright, and yet, in cases like Chavez, we say that the result of that isn't wiped away, but that
Sure.
Loper Bright's still there. What is the test that you would have us apply post Chavez and Ozarumba to Fan if the only case that I had that mattered
Is Loper Bright.
is Loper Bright?
Sure. Ozarumba specifically leaves open the question.
Yep.
So
But whether Chavez left it open, like Ozarumba doesn't answer the question. If Chavez closed the door, we're bound by Chavez. It's the earlier panel. But
Sure, I
put
recognize
that aside for a minute. Assume it's an open
So the
question.
Well, with the time I no longer have.
The chief will let you
Sure.
answer this one, I think.
Absolutely, go ahead.
I could not say it any better than Judge Bumate said it in his dissent from denial of rehearing in the Ninth Circuit's decision in Lopez versus Bondi. I don't know if your honors are familiar with that. We
Yep,
cited it in our
quite.
reply brief. But I just don't, this is an issue that has divided the circus in the wake of Loper Bright, and I have not seen even an attempt to answer the arguments that Judge Bumate makes in his dissent in that case. And it would simply turn vertical stare decisis on its head to say that circuit courts are required to continue applying their pre-Chevron jurisprudence even when the Supreme Court said that Chevron itself was wrongly decided.
So can I,
Yeah.
do you mind,
ahead.
Chief?
No, go
So take a hypothetical for a minute to say why maybe that doesn't make perfect sense. If we had a case like Fan and we had this type of circumstance, it might well be that Loper Bright creates a conflict, right, in methodology. But if Fan happened to reach the best statutory reading, even though it did so in applying Chevron, there wouldn't be any irreconcilable conflict, and we would continue to apply Fan.
Sure.
Right, if it applied the best statutory reading.
Correct,
right?
but I don't read Fan as saying this is
No,
the
I
best
know, this
statutory
is
reading.
hypothetical. This is,
Okay.
yeah, it's a hypothetical Fan, it's not Fan itself.
Understood.
But that means that we're not just throwing away all of our Chevron cases, right? We're having to ask whether Loper Bright is creating an irreconcilable conflict with that, and mere methodological differences isn't sufficient, right? The Supreme Court suggests that. It seems like to me that's clear from Chavez, that methodological differences aren't sufficient. But what we don't sort of answer, like what seems to be open, is what is that test? And it seems like in other contexts, we've applied this idea of like an irreconcilable conflict or severely undermine the result, not just the methodology.
We only think that cases are irreconcilable with Loper-Bright to the extent that they reached the result that they did only because of Chevron deference.
Right.
If Chevron was the driving force.
So they're at step, they're not step one.
Step two.
They're step two, and they're reaching a result where they say it is a reasonable, even though effectively, like, we would now say it's not the best read.
Correct. If it's clear from the opinion that the court was not exercising its independent judgment, then we would say that the question remains open in light of Loper-Bright.
And what do you say, where does Fan fit in that analysis?
Well, we think Fan, and the government says in their brief, that they deferred to the board under a matter of Pickering. So we read that as a Chevron case. There was a separate part of the opinion, part 3, that did go into statutory interpretation. But again, our baseline is that Fan is distinguishable because it did not squarely address the effect of a true vacatur. The statute in Fan was
But it adopted Pickering as the interpretation of this statute. I mean, it adopted it by deference to the board and, sort of at the time, overwhelming support in the other circuit.
Sure, yeah, I mean, that's our frontline position. If the court doesn't accept it, then our next position is it's irreconcilable with Loper-Bright, and then.
And Hewitt.
And Hewitt.
Right.
And
I
certainly
bracketed Hewitt for a minute, but you would put Hewitt back into that
Yes,
conversation.
I think the conflict is most irreconcilable with Hewitt itself. If you think of it this way, if Hewitt had been decided before Fan, would Fan have said what it said with regard to pure vacators? I don't see how it could have said that. I think we have, to be clear, we have no quarrel with the outcome of Fan with respect to the specific statute at issue in that case, because that
I
was a
appreciate
set-aside.
that since I wrote Fan.
We're all aware of that, trying to be as nice as we can.
The outcome of Fan, we think, was correct because, as the D.C. Court of Appeals has said, a set-aside is distinct from a vacatur or reversal because it does not alter the fact of conviction. So again, we have no quarrel with the outcome of Fan. We just don't think Fan can be reconciled with Hewitt to the extent it can be read to also apply to true vacators, as occurred in this case.
I want to ask Judge Keenan if she has any additional questions of you.
No, not at this time.
Because I do have one other in light of the question she asked you about the hurdle you have to face with respect to the voluntariness of the plea. I want to be sure I understand your argument is that with respect to the state court, even if they got the law completely wrong, if the claim was that I didn't understand the immigration consequences of my plea, and all of that might have been foreclosed either by, collateral consequences or some other prohibition on getting to that point. If the state court had granted the motion on that basis or the basis of newly discovered evidence, even in the face of no such evidence, we shouldn't look behind that.
Precisely. I think the court has to take the order as it finds it, just as it takes judgments of conviction as they find them, even if you were to read the plea colloquy and it was overwhelmingly clear that what the defendant did not satisfy the elements of the offense. If a litigant tried to present that argument to the board or to this court, they would say, tough luck, go file a motion for post-conviction relief in North Carolina court.
But in your, you agree, you bear the burden on this.
By preponderance of the evidence.
And if we read the order on its face, it actually doesn't tell us why it's doing it. We have to, even under your view, we have to go behind the order and suggest that, well, it must have relied on the grounds given in the motion. Or maybe something like, for you to meet your burden, you have to go beyond the order.
Yes, I think the
Right.
order,
I mean,
the order
that-
in conjunction with the motion.
That's
Yes.
part of the problem with Pickering, right? Is
Yeah.
that it requires courts, federal courts, to identify or figure out what a state court vacatur is, and accepting perhaps that the chief's point may well hold if the state court's order on its face is clear about what it's doing. That we might or might not want to look behind it in that circumstance. But where it is not clear on its face, the only way you can meet your burden under Pickering is to go beyond the face of the order. And I agree, your argument is I don't have to go very far behind, right? But you're still going outside of the four corners of the order itself.
I suppose that is correct, yes.
All right, thank you very much.
Thank you, Your Honors.
Mr. Needle, welcome.
Thank you. Good morning, Your Honors. May it please the Court, Jonathan Needle, Department of Justice, on behalf of the respondent. This case illustrates very well why matter of Pickering exists. The state court documents that the petitioner submitted to the board really tell us nothing about why her conviction was vacated. What we do know is that she waited about 15 years after the conviction was entered to challenge it before the North Carolina court, and she brought that challenge only after the immigration judge found that she was ineligible for relief because of that conviction. Not only that, but she filed...
All right, so those are, I know I should wait longer to let you keep talking, but you start off by saying this is why Pickering is there, and I will grant you that Pickering seems like a really great idea. Help me understand, when I look at the statutes, how in the possible world I can get Pickering out of the statute. Like, I understand how I can get no vacated convictions count, which is what your colleague is asking, or I can understand how you can say all vacated convictions count, right? That seems like a hard argument, but it's at least a plausible one. What I can't possibly figure out is how I look at 1182, 1101, and draw this like middle ground. It depends upon what was between the ears of some state court judge when they vacated the order. Like that line to me is like, frankly, does not make a lot of sense. Can you help me understand how I might get Pickering from the statutory language?
Well, starting with the statutory language, the INA provides that a conviction is a formal judgment of guilt entered by a court. And that, in and of itself, indicates that Congress's intent to give some effect to the historical fact of the conviction.
Okay, which, all right, totally fair. And so in that world, we might say, doesn't matter if it's vacated or not. I certainly understand they could have intended, or I would say conveyed with the words they use, that the historical fact controls. And so whether it's vacated or not doesn't matter. I understand that argument, and we can talk about the other one. But help me understand how I take that and get an answer that suggests that what matters is what was between the ears of a state judge in granting the vacatur.
Well, I think it's important to emphasize that a definition of conviction did not exist before 1996 when Congress enacted that provision. As a result, there was no uniform definition for the agency to apply. And the purpose was to enact this uniform definition, that it's not dependent on what a state court orders, because the board had previously recognized in matter of Oscock that...
Well, but it obviously depends on what a state court does, because it has to be entered by a court, right? At a bare minimum, right? It's a question of what was entered by the court. What is the formal adjudication of guilt entered by the court?
Yeah, that's correct. But the board has traditionally recognized that, recognized state court procedures for setting aside, vacating, expunging, annulling a conviction. That body of law developed over the course of decades, and the agency found that it was, it led to unfair results. It was confusing, and this was in the matter of Oscock case, which Congress referenced in the legislative history for the 1996 amendment. And again, it made clear its desire to impose a uniform definition of conviction that did not depend on the exclusively on the fact that a conviction was vacated or otherwise set aside.
So this, I think this
Okay,
question might...
Mr. Needle.
Oh, go ahead, Judge Keenan, go
I'm
ahead.
sorry.
No, go ahead, please.
Okay, Mr. Needle, could you address, excuse me, what I see to be your Hewitt problem? The Hewitt language is very explicit. The court said vacated orders are void ab initio and thus lack any prospective legal effect. Why doesn't that end the inquiry here?
You're correct, Your Honor. Hewitt contains a very bold statement about vacators. However, it should be emphasized that Hewitt has nothing to do with the INA. It has nothing to do with immigration.
But
And-
why shouldn't it apply? The court didn't cabin its language, which it frequently does, and it's very careful not to overextend. It's very careful not to just simply toss a bomb. And it seems to me that in saying specifically that these orders lack any prospective legal effect once they're vacated, why wouldn't that apply in immigration? Just because it wasn't an immigration case, it appears that the language is just so broad that the court is drawing a line. It's a line in the sand, and for whatever reason, it's decided to draw it.
I think the case is distinguishable in that it arose in the context of the First Step Act. It involved a federal sentence that was vacated by a federal court pursuant to a U.S. Supreme Court decision.
Sure.
That
It was different, absolutely, but I'm talking about the language. The language is broad. The court doesn't say in the context of the First Step Act, when you have a remedy enacted by Congress and the court is being asked to consider what has happened before the remedy is sought, the court didn't qualify its language. It just got right out there in front and said, these don't have any prospective effect. Seems like the court was saying to me, and then if you could respond, the court was saying, we don't want to get into this line splitting here, trying to jump through hoops, trying to define what any judge might have been thinking at an earlier date. It's essentially saying it wipes the slate clean. So why doesn't it apply in this case? Other than the fact it was a First Step Act case, no question, the facts of the case were different. But I'm talking about the principle of law that was so broadly enunciated.
Well, the court made much of the fact that in construing the relevant statutory language, that it was written in the present perfect tense, where the statute said that reduced penalties under the Act apply only if a sentence has not been imposed as of the date of its enactment. And the court construed that language as being forward-looking and being a basis on which the defendants could be granted relief.
So is your argument that when the court says there's no prospective effect, that mattered because of the present perfect tense, that at least there, they were asking about this prospective effect? And it contrasts in footnote 6 with the 922G statute, right, which didn't have that language. And the court sort of acknowledges even a subsequently vacated conviction can form the basis of a 922G conviction. And so it's not that it has no effect, right? It's not really void ab initio, but it just doesn't have this prospective effect, which is the present perfect tense.
Correct, and the majority opinion suggested that if the statute was written in the past tense, then the outcome may have been different. And it's important to emphasize here that the provision of the INA that we're dealing with, the definition of conviction, is written in the past tense. A formal judgment of guilt entered by a court.
So entered in that sentence, though, is not actually a past tense verb, right? It's actually describing the judgment, right? So it's not, you can't write that in the present tense, right? Because it is not a verb. It's not saying the court entered a judgment. It's describing the nature of the judgment, right? As one that was entered by a court. So it's not a past tense verb at all, right? It's a description of the term judgment. So it's not actually in past tense, is it?
I'm not sure. I think it could be written in the present perfect tense. Conviction has been entered. Whether that is a distinction without a difference is something that would require some additional thought and reflection. But I mean, it's clear.
Okay,
even
counsel, well, I'm sorry, were you finished?
No, Your Honor, you can go ahead.
Okay. Let's get back to that North Carolina statute. Were there any other statutes under which relief could have been granted in North Carolina to reach the result that was reached in this case?
I'm not aware of any statutes based on the asserted justification in the petitioner's motion where she would be entitled to relief under a different provision of North Carolina law. But also, it's not, the
But I'm
agency.
asking you a more specific question. Were there any other statutes? And you're saying you don't know? Or is the answer no, there weren't any other statutes under which she could have obtained the relief that she was seeking?
There's certainly a statute and case law under North Carolina law for ineffective assistance of counsel claims, but the motion that she submitted gave no indication that that's what she was asserting.
Right, so were there any other statutes in North Carolina under which she could have gotten this relief on the basis that she requested it? In other words, I want to make sure that we're looking at the only form of relief that was available to her. Was it yes, that it was the only form of relief, or was it no?
I am not in a position to give a definitive answer to that question, but I think here it's important to emphasize the posture of this case before the board, where the petitioner had already been ordered removed. She was filing a motion to remand with the board to send the case back on account of this intervening development. And that meant, as this court has repeatedly recognized, that she has a heavy burden to demonstrate that she is entitled to a remand. This is a factual question. She could have submitted virtually anything to support her motion, but she chose to submit documentation that the board found wasn't clear as to the basis for the vacator. And we submit that this is a determination that's reviewed for abuse of discretion. Looking at the record as a whole, which the board analyzed closely in its decision, the ultimate determination that the conviction survived for immigration purposes was reasonable. This is not a legal question.
Let's get back to the standard of review, though, Mr. Needle. Why isn't this a fundamentally legal question here? The effect of the statute, the applicability of Pickering, the applicability of Fawn. Aren't we confronted here with a legal issue rather than a factual issue that would implicate the court's discretion? It seems to me that, we've got the Gonzalez versus Garland case in 2021. We pretty clearly said that if it's a legal issue, the court in this procedural posture considers the legal issue de novo. So why wouldn't this be de novo?
Well, there certainly are legal issues. They primarily relate to the petitioner's challenge to Pickering and challenge to the agency's interpretation of the INA.
And to going behind a court order, whether we can go behind the state court order.
That's correct. But the primary issue here is whether the board reasonably determined that there was an ambiguity, that the board could not discern what the basis for the motion or the vacator was.
So I'm just in sort of order of operations to understand the argument you're making. Whether FAN is good law and whether the Pickering test applies, that's a legal question we review de novo.
Correct. Well, yes, correct.
If Pickering applies, how Pickering was applied, as a factual matter, the facts underlying Pickering by the board, that's an abuse of discretion / substantial evidence. But that's sort of downstream of the question of whether Pickering itself applies.
Correct.
Right. Their interpretation of the order, right, that may well be substantial evidence, but whether Pickering applies is a de novo question.
Correct, and we point to the FAN decision as stare decisis. FAN cites to no fewer than 5 circuit court decisions upholding the Pickering distinction, according to Chevron deference. And, even though Chevron has been.
Can you, since you bring up Chevron, can you answer the question that I asked your good colleague? If for a minute, just assume Hewitt doesn't exist, or that it's not sufficiently clear to require us to abandon Fan, what would you have us do as applying Loper-Bright to Fan as prior precedent? Right, Fan obviously methodologically is inconsistent with Loper-Bright, and yet, the Supreme Court seems to suggest like that methodological challenge isn't sufficient to throw the result of Fan away. What would you have us do?
Well, I think there's some relevant language in the Chavez case, which was mentioned earlier, where the court said that Loper-Bright may have instructed us to review agency interpretation with a keener eye. It didn't write off respect for settled, consistent, and persuasive precedents. And that's what we have here. We have a body of law that has existed for decades, acknowledging the Pickering distinction.
So go back to the persuasive question. This is sort of back to the question I started with, which is like, it seems like at a bare minimum, you have to be able to make a plausible argument that Pickering comes out of the statute that you're interpreting, right? I mean, maybe it doesn't have to be maybe it does, maybe it doesn't have to be the best reading of the statute. But part of the challenge that I have here is, like, I don't even understand like a plausible argument that the statute requires trying to divine what was between the ears of a state court judge when they vacated the judgment, as opposed to asking whether it was vacated or not. Like that I get from the statute, but the sort of underlying reasoning behind the state court judge and how we might try to figure that out seems to me to be a wholly unpersuasive endeavor. Like it, and I guess I'll just give you one more time to sort of help me understand how I get Pickering out of 1182 and 1101.
Well, again, Congress expressed its intent to give some effect to state court modifications of a conviction. That is consistent with the board's practice over decades, and Congress legislated based on that history. And there was, Pickering acknowledged that and developed a test to ensure that the principles of federalism that are embodied in the INA are applied, where the government is.
It seems like Pickering is like the most anti-federalism like doctrine we could have. Right? It requires us like to divine the underlying intent of state court judges in issuing the orders that they issue. I mean, that seems like a wild thing for us to be doing.
Well, I mean, I don't want to make the petitioner's argument for him. I would.
You're an officer of the court. You get to like tell us what you really think, whether it helps your client or not, right?
Correct. And there are courts that have found that the plain language of the conviction statute does not explicitly exclude vacators. I think that's a minority view. It may have been, I'm aware of a Fifth Circuit case that may have been overruled, but like I said, that's an outlier. And I would imagine that the government defended that position before the Fifth Circuit when it came up. But
Can I take you back to the application of Pickering? And I know that remains an open question apparently, and I guess we'll think about that. But assuming Pickering is what we should be applying here and going back to the state court documents, and I realize that this is not what's in the record, but let's assume that the motion had been filed pursuant to the statute that was actually identified in the motion, and there was no mention of this collateral consequence issue. It was simply a request for relief based on newly discovered evidence, plain bones motion, no description of what that newly discovered evidence should have been, and the court, State District Court, grants relief based on that motion, again, with no description of what the newly discovered evidence should be. Would we look behind that order?
I think in this context, it would be the petitioner's burden to provide sufficient evidence.
Well, but on the
as-
face of the documents, the relief was granted based on newly discovered evidence pursuant to the terms of the statute. What more do we need?
Well, I think Pickering and other case law establishes that the government or the agency has to independently scrutinize the basis for the vacator in order to determine whether it was based on a substantive or procedural defect. And
So then, Mr. Needle, essentially you're saying that in order to meet her burden of proof, or in order for a petitioner in similar circumstances to meet the burden of proof, they'd have to go behind the court order. I mean, it seems to me that it's a tough proposition because we've said time and again, we're not going to look behind the order. The order speaks. And now you seem to be telling us that in order to meet her proof burden, the petitioner has to prove evidence beyond the face of the court order. Is that correct?
I don't think that the petitioner has to submit the additional evidence, but she does have the opportunity to do that, to present extrinsic evidence in the form of conviction records, declarations, court transcripts, in order to illuminate the basis for the decision. And
Would that be, in your view, would that be necessary if you had a court order that was clear, that said, in the chief's hypothetical, I'm granting under subsection C, because of the existence of newly discovered evidence, the requested vacatur? I mean, if the trial court, state trial court said that in the order, surely the board would have substantial evidence if it chose to accept that as the basis, right?
I think that would seem to be within the board's discretion.
Right, and maybe your argument is, if the board rejected that, we would then have to have a discussion about whether, that rejection and whatever the reasons it gave, accorded with the standard of review that we've got. But it would certainly be within the board's authority to accept a clear vacatur order as providing the real reasons behind the vacatur.
I mean, with the qualification that the board doesn't have to scrutinize the statute under which the conviction was vacated to, consider all possible scenarios where it might apply and to sort of divine what the court was thinking in doing that. And the fact that there was, in the hypothetical instance, the absence of any justification for granting the motion or for seeking relief suggests, it provides at least circumstantial evidence that the conviction was not vacated for substantive purpose.
Including the timing and other factors that are sort of
Correct.
outside
And
of the
the
four
board
corners.
can properly consider the timing of the vacator as well as the effect that it would have on the petitioner's ability to pursue relief.
All right, Mr. Needle, before I let you go, Judge Keenan, do you have anything else?
No, thank you.
Thank you very much.
Thank you.
Mr. Winograd.
Thank you again, Your Honors. In response to Judge Keenan's question, we know that Hewitt applies beyond the criminal context because the court itself cited a hypothetical statute involving a stimulus provision. So we know the Supreme Court itself believed that its decision would apply outside the criminal context. In terms of,
But if we read the line that Judge Keenan quoted to us, that it is void ab initio and has no prospective effect, that would effectively overrule the 922G case, whatever the name of it is, where it says a subsequently vacated conviction can form the basis of a previously imposed 922G conviction, which means that it wasn't void ab initio, that it had prospective effect, even though it was subsequently vacated. So I take the language there to be a reference to this present perfect question of whether it is at present a sentence has been imposed. And in that sense, the court is right, but you have to read it a little bit in context. If you take that one
Sure.
sentence out of context, it reads out footnote 6 and sort of suggests to us that there's a different holding than what we've got.
So I think if we're concerned about verb tense in this case, the statute to look at is not the definition of conviction, but the ground of inadmissibility, 8 U.S.C. 1182 A2A1. And it says, it refers to any alien convicted of a controlled substance offense. Now,
Right. The challenge is that doesn't really answer the question of whether convicted in that instance is a status question or a historical fact question.
Sure. I would point your honors to your 2023 decision in Sela versus Garland, 75 F. 4th 355. That case involved a provision that referred to any alien granted asylum, and this court held that in that sense, granted asylum granted was used as an adjective, not as a past tense verb. So we think the analysis of that case tracks onto this case as well.
And in doing that, what you're saying is convicted in this instance
It's an adjective.
is an adjective describing alien,
Correct.
right? And therefore, the second move you make in that argument is therefore, it is, why does that help us identify that it's a status question, not a historical fact question? Because it, as an adjective, it's historically true that the alien was in the past convicted of X, right? But it's also true, right, as a historical fact, that conviction's been vacated, but as a historical fact, they were once convicted, right, as a factual matter. I'm not saying it's the best reading, but it's a
Sure.
reading, right? So I guess why does the adjective help
Because
pick between these two?
When a past participle is used as an adjective, it is used to describe a present state of being. That is what the court found in Sela. That's my grammatical understanding. And if you also look at the rest of 1182, it refers to an alien convicted of or who admits having committed or who admits committing acts. Admits is also in the present tense. So I think Congress was clearly referring to aliens who are presently convicted.
But
or
why don't we
presently
think
admit.
those is like slightly, I mean, why do they use the convicted and then they switch to admits?
Because both, one is a adjective in the describing a present tense of being, present state of being. The others are present tense verbs. I think the point is, at the time of adjudication, the person has to either be convicted or admit having committed the crime. If I could just quickly move on to return to your question about stare decisis and loper bright. If loper bright means what the government says it means, it would mean that Fan itself would preclude the board from ever overruling matter of Pickering. That was a concern that Judge Wynn noted in Ozarumba. Now, I think the only way it could do that is if the board were to find that it couldn't be reconciled with Hewitt, because of course Supreme Court precedent is supreme. So finally, I would just like to float a
But arguably,
Yes.
if we disagreed with that, if we wrote an opinion that says Hewitt is not inconsistent with Fan and Pickering, presumably the board would be bound by that too.
Yes, the board would be bound by that, but my point is just what is the best way to read Loper Bright? And if you read Loper Bright the way that the government reads it, it means that any time a circuit court deferred under step 2 of Chevron to an agency position, that means the agency's position, the agency could never reconsider its position. It would be bound by a circuit court decision finding that its prior interpretation was permissible, even if the court didn't think it was the best reading, and even if the agency itself does not subsequently think it's the best reading.
All right, thank you very much, Mr. Winberry.
Thank you, Your Honors.
I want to thank both counsel for their fine arguments in this interesting, grammatically intense case. We'll come back and greet you, come down and greet you, and then adjourn for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.